Good afternoon and welcome to the Senate Judiciary Committee meeting of January 26, 2022. We're going to start the day by opening the public hearing on Senate Bill 292 and recognize the prime sponsor, Senator Reagan.
Good afternoon, Madam Chair and members of Senate Judiciary, for my inaugural appearance before the Judiciary Committee. So, I'm Senator John Reagan from Senate District 17, and I bring to you today Senate Bill 292 at the behest of the Department of Corrections to bring you the bill that requires a notice of an arrest by a county detention facility to a probation or parole officer. And there's representatives here from the Department of Correction in case you actually want to know any particulars.
Okay, thank you very much, Senator.
Excellent job, guys.
Okay, the chair will call Bob Oxley. Good afternoon, Mr. Oxley.
Good afternoon, Madam Chair.
Good afternoon. My name is Bob Oxley. I'm the Director of Field Services for the Department of Corrections. We're looking to have a simple statutory change to Senate Bill 292. As the bill currently reads, when a probation or parolee is arrested on a violation, they're brought to the nearest county facility. From the time of arrest, we have 72 hours to show up and do a preliminary hearing. If through no fault of our brothers and sisters in the county correctional facilities, we've missed that 72-hour deadline on occasion because we weren't notified in time, because it's from the time of arrest. We're just looking to change it to 72 hours from the time the probation or parole officer is notified. And as we originally wrote it, we wrote in the superintendent of the facility will contact us, and we put a change in to amend just to say the superintendent or designee would just notify us, and then the clock for the 72 hours would start ticking once we're notified.
Okay, because you said you put in an amendment. Do you know?
I'm sorry, we didn't, ma'am. We just wrote it in that.
Okay, so you're requesting that it be amended?
Yes.
Okay. Okay. Thank you. Are there questions? Senator Khan.
Thank you, Madam Chair. Thank you for bringing it up. Is there any unintended consequence to this notification? Meaning the 72 hours is clear, the notice to parole officers, that's clear, but is the time from when the person arrives at a county corrections institution to the notification to the parole officer, is that going to add to the 72 hours?
It would if the superintendent or their designee did not notify us in a timely manner. And there is nothing currently in the statute that puts a time frame on the superintendent or the designee to actually notify us. But it's the simple, the clock would start as soon as we're notified. I hope that answers your question.
Follow up?
May I? Thank you. So is there any wording that could, I mean, you know, the unintended consequences that somebody is interned at the county corrections before a preliminary hearing for longer than 72 hours. That's not what you intend.
No, sir.
Certainly on your end, you're not intending it. I'm sure on the county's end, they're not intending it, but it's possible that we might be extending it by doing what we're doing here. And if you could look at, I mean, we've got an amendment coming anyway, we're going to add or designee. If there's something we can do here, I'm totally sympathetic with what you're trying to do. It's just I'm also sympathetic to the person who might be there for longer than 72 hours, plus the weekend, plus the time to contact.
Yes, sir. And that's the original reason why we set this into motion is because we didn't want that to be delayed. I think we'd be amenable to adding in some more language, putting a time frame on the county facility once they have them in their custody to how long they tell us. And then once we're told we can move, we have the 72 hours to do their preliminary. And to answer your question, Senator, yes, that's what we're trying to avoid, is extending or prolonging their stay.
Madam Chair, I just would hope we'd get that information before we take a vote on this.
Yes, I would agree. Are there any further questions? Mr. Oxley, I've gotten a letter from the Association of Counties, and they're recommending that it makes more sense for the arresting law enforcement agency to notify probation of the arrest and where the offender is located. And I have concerns, as well as Senator Khan, that you're going to be holding someone for at least 72 hours from the time that you're notified, and is this going to add more time for them being detained? And we really don't want to see that happen. And it's just, there's no assurance that there's some sort of a time frame to what Senator Khan was talking about, that they have to notify the superintendent or designee has to be in contact within a certain amount of time. But what do you think concerning the recommendation from the Association of Counties?
Well, thank you, ma'am. I would say we would like to see it remain with the facility itself. Some of the smaller police departments around the state may not have the time or the manpower to make sure that we're notified, where once they arrive at the facility, they have, in most places, they have the staff that can then notify us within that 72-hour time frame. And again, we wouldn't have a problem putting an amendment in there stating that, I'm not sure what we use for a time frame, but the superintendent would have X amount of hours to notify us, and then we would have 72 hours to get the hearing done.
Okay. Are there any further questions? Okay, seeing none. Thank you very much, Mr.
you.
Oxley.
Thank you.
Are there any other, Kate Horgan. Each one of these sheets is different, so sometimes you really have to look.
No problem, Madam Chair. Members of the committee, my name is Kate Horgan. I serve as the Executive Director of the New Hampshire Association of Counties. We are not taking a formal position on this bill, but Senator Carson did bring up a suggestion, and just to expand a little on why we think the arresting law enforcement officer would probably be more appropriate, is if there are questions about the situation or what happened when that individual was arrested, we may not have all those facts. That arresting officer, law enforcement, would have all those facts. And then, again, we would just like to express our concerns around the 72 hours, because let's say an emergency happens at the jail, you could potentially end up holding someone for an additional 72 hours because a pipe burst at the jail and we were unable to process someone immediately, so they would be held longer than that 72 hours. I'm happy to take any questions that I can answer, and I'll conclude my testimony.
Thank you very much for your testimony. Are there any questions from the committee? Senator Khan?
Yeah, thank you, Madam Chair. Thanks, Kate. And if there's any wording that you want to suggest, the same question as was asked of Mr. Oxley, I don't think that's anybody's intent, but the wording is open-ended enough that that possibility of extended holding could take place. And if you got some words that we can add in here, that probably.
Yep, and we're happy to
be
work
good.
with Mr. Oxley offline to see if we can come up with some language that works for everybody.
Thank you. I was going to ask you if you were willing to do that. Okay. Are there any other comments, questions? Okay. Seeing none. Thank you very much, Ms. Horgan.
Thank you.
Are there any other members of the public that would like to speak to Senate Bill 292? Okay. Seeing none, we'll close the public hearing. Yes, we got 2 minutes. Bill, I'm next. Here you go. Thank you. Okay. There you go. Yeah, I know. Well, we did all the hard ones. These are, well, there's some more. I mean, there's a few more. Okay. That way I have it right here. I'll just put it in my bill file.
That's trying to think what you're about.
Nice and soft.
Why is it too loud?
What?
Is it too loud when I do it?
No, we're good. No, I was
Okay.
kidding. Senate Judiciary is back in session. The Honorable Senator Carson, she'll be introducing Bill 297. Thank you, Senator Carson.
Thank you, Mr. Chair, and good afternoon. For the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have for your consideration this afternoon Senate Bill 297, relative to obtaining out-of-state discovery and testimony. This bill allows testimony and discovery from a foreign jurisdiction needed for litigation pending in New Hampshire to be obtained without a court-appointed commissioner and pursuant to the procedure in the foreign jurisdiction. There are folks here who are going to be able to answer your questions much better than I can. So I would ask you to reserve your questions for when they come forward. And thank you very much.
Thank you, Senator. I'm assuming there are no questions. Great, thank you, Senator. Rory Cornell.
Good afternoon. My name is Rory Parnell. I live in Manchester, and I'm one of two partners that run a six-person or six-lawyer law firm in Londonderry, New Hampshire. I wanted to thank the committee for your time today and allowing me to speak, and especially Senator Carson. Thank you for sponsoring this bill and your work in getting this in front of the committee. As discussed, this is a somewhat boring and benign bill. This is basically just providing a very small fix to a loophole in our statute. So most states that have adopted the Uniform Deposition Act have adopted this provision, the one that is being proposed today. And what this does is it removes a step that we have to take in New Hampshire if we want to take a deposition. In your materials, you'll see an example from Maine where you're trying to get out-of-state discovery. So presently, if you're out of state and you want to get discovery in New Hampshire, all you got to do is comply with the statute and you can get discovery. But if you're in a deposition or discovery information from someone outside of the state, you have to go and file something with the court that must get approved to appoint a commissioner. The commissioner appoints someone to take the deposition. It's an extra step in the process that really is unnecessary. This fix is very simple. It just allows us to go straight to that jurisdiction, comply with their rules, we get discovery, we get whatever we need, a subpoena, deposition, and we're done, and it's a lot faster. So it actually eliminates a step in our current court system that's really unnecessary, frees some of the time burden with the court system, which they could very much use right now, and really hasn't changed anything functional other than giving lawyers in New Hampshire that represent New Hampshire citizens the same tools that other states that have adopted this act have. As noted in the materials that were provided to you today, 43 of the 50 states have adopted this in its entirety, and we're simply just joining the fray there. So it's a very simple change, just to make things a little easier for the courts and for the folks that are being represented by New Hampshire lawyers to just get information from out of state. Really a simple fix. Happy to take any questions and really appreciate you guys spending the time to consider this.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, Thank you very much. Oh, Senator Khan.
Yeah, thanks for your testimony. Am I to understand then that you're looking for the same kind of non-commissioned jurisdiction? Is that part of the current agreement, the interstate agreement?
So the way it works in the states that have adopted what we're proposing here is you have to comply with that jurisdiction's requirements. So you go straight to that state and their rules. Just like if you're from Vermont or Maine, you go straight to New Hampshire and comply with the rules. The difference that we have in New Hampshire is you can't go straight to that state right now. You got to go file in court. The court has to make a ruling, and once they make a ruling, then you can go. And so it's just extra paperwork for the court. It's really unnecessary. This is a very simple fix, and I'm sure a lot of judges would be very fond of this to free up every little second we can for them as they continue to catch up.
Thank you.
Are there any further questions?
Just a
Senator Gannon.
little question just for me, because I hardly ever practice. So when you go to do discovery somewhere else and you're using their rules, do they vary much state to state? The rules, do you have to like brush up on what the rules of discovery are? Or?
You have to be aware of what those rules are, but generally they're very similar. That's part of this process, is to make it uniform across states, so
Sure.
it's easier for us to get access to things, because it's
Thank
the
you.
modern era. So I appreciate that question, Senator Gannon, and
you.
apologize for not thanking you, Senator Khan, for your question. Thank you.
Thank you.
Okay, are there any further questions? Okay, seeing none, thank you very much.
Thank you so much for your time today, everyone.
Are there any other members of the public that would like to speak to Senate Bill 297? Okay, seeing none, we'll close the public hearing. We've got about 9 minutes.
Does this need any adjusting to do what he was just asking? Is that another, so how do we accommodate what his request is?
Senator, weren't you paying attention?
Sorry. Be nice.
I'll take your answer.
Yeah, I think that this is what you're talking about here, or?
Well, just what the gentleman was just, Mr. Cornell was just saying. We have something that deals with foreign jurisdictions.
Right, foreign means not New Hampshire.
Good enough. It-
Okay. So we have a motion of ought to pass?
Ought to pass.
Okay.
On. I made the
Senator
motion of
French
ought
and
to
seconded
pass
by
on
Senator Gannon.
297.
So, okay, is there any further discussion on Senate Bill 297?
I just want to make sure Senator Khan's clear on this. Senator Khan, you all set?
now that I understand that Maine and Massachusetts are foreign jurisdictions, I'm willing to vote in favor of this.
Great.
Okay. All right, is there any further discussion, debate? Okay. Seeing none, all in favor say aye.
Aye.
Any opposed? Okay.
Move consent.
Okay, Senator French
Please.
moves consent
I'll
calendar.
second that.
Okay.
Senator Khan seconds.
Okay, moved by Senator French, seconded by Senator Khan. Is there any discussion on the consent motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay, and I will take this one out. Okay, can I get a motion to come out of executive session?
Made by
moved.
Senator Khan, seconded by Senator French.
Senator Khan, do you acquiesce? Okay, I
Whatever
want to
he
make
said.
sure.
He's just
Okay.
too quick today.
I know.
Yeah, it was a
he's
cup
quick.
of coffee.
I want to
at
go
lunch.
smoke.
I know he had a second cup of coffee, huh?
Yeah. Okay, all in favor say aye.
Aye.
Any opposed? Okay, we're out of executive session. the committee will come out of recess, and we're going to open the public hearing on Senate Bill 327 and recognize the prime sponsor, Senator Gray. Good afternoon, Senator.
Thank you very much. My name is James Gray. I am the senator representing District 6, which starts up in Barnstead, Alton, Gilmanton, goes down through New Durham, Farmington, and into Rochester. I'm here to introduce Senate Bill 327 relative to the duties of the Register of Probate. I've been here before, and I hope not to have to come here again. So I'm hoping that you'll find favor in this. Register of Probate is a constitutional office specified in the New Hampshire Constitution. I believe the intent of that was to have someone other than the judge that the people could go talk to, especially in these trying times where we're doing probate information. This bill has been discussed with the good Supreme Court and Superior Court representatives. We've listened to all of their arguments and tried to address every one of them. Where they thought there was conflicts between the things that they did and the things that the Register of Probate did, we resolved those conflicts. Where they were going to supply equipment or other access, we took out that stuff. We pretty much did everything that they objected to. We were going to have them share a part of the fee that they collected for probate with the counties, knowing that they set their own fees, and if they needed additional funds, all they needed to do was to raise their fee just slightly to provide that money. They chose not to, and so in the bill, again, to resolve the conflict, we have a $25 fee that goes in, and that fee is what we use for the funds to pay for this. Why is $25 something that would help? Unfortunately, I had a son that passed away just a couple of years ago. And when I had an occasion to speak with Justice King, I told him that my daughter-in-law was charged $1,700 for modifying the estate and probate. He said, she got taken. Most of these things don't have to go through a lot of judicial review. If you look in here, in the testimony that was provided by them, it says only 3% of the cases require a hearing. Part of the problem is people, like my daughter-in-law, are suffering from a loss, trying to deal with all of the financial and other things that are going on because of that. And we say, oh, you have to file this electronically. You have to do this. You have to do an inventory. You have to have somebody appointed, as the administrator. You have to, you have to, you have to. And all of those things, as you go forward, make it more and more difficult for the person to comprehend what's going on. And then they go in and tell you, well, gee, we provide telephone service. Good, absolute good. But when you call up, you get sent to Concord. Are you going to get the same person every time? No. Are you going to get the same person 2 out of 3 times? From what I hear, the answer is still no. If you look at their testimony and add up the number of cases that they talk about for all of the things that the probate court would do, and then go to the next page for 2019 and look at the number of calls, 46,396 calls. And if I take every one of those cases and I divide it out, I get 4 calls per case. And if these are attorneys that are doing most of the stuff, how many calls are the attorneys making, and how many calls are the people who are trying to do their best to do this pro se making? And those 4 calls, that's averaging over 18 minutes that they've spent on the phone. From what I'm hearing, it's partly because they got a different person explaining the things that they and are still working on. What we're trying to do here is to provide somebody in the county, not being an advocate for the person, but a person who can help to guide them through the system, help them to understand that they need an executor assigned, help them to understand how they do an inventory, help them to understand that the process steps that they're going to have to go through. And we'd like to do it without charging them any more than $25. And those people who do choose to hire an attorney, well, we're going to charge them the $25 too, to help out the people who either can't afford to go and hire an attorney, or so that's the thrust of the bill. If they bring up other things that you would like me to respond to, I'd be more than happy to. They did send you 8 pages. The last time this bill, when it got over to the House, the thing that was a problem there in the House, and there was testimony from the county people that the Register of Deeds didn't want to share space with them. Okay, so what did we do? We took that out too. All right, we've done everything that we can. And if every county going to have the same type of person, well, some of the people that do have experience, that have run for the position of Register of Probate, are willing to help train the other ones. We would like that training coming from the courts. Courts do not want to agree to provide that on an ongoing basis, so we're looking at other ways of doing that, and that is some of these people that do have experience and have served in those positions before. So we've been over backwards. We're just asking that we get a fair shot and try to help the constituents out there that are trying to, in some of the most trying times in their lives, trying to get through the process. And like my daughter-in-law, who most everything that they owned, her and my son, was in a trust. There was 1 vehicle and 1 bank account. And that bank account was not a large bank account that needed to go through probate. And exactly how much of that $1,700 went through the probate, but I do have one lawyer's opinion that she got took. And I think we developed a system that allows these people to be taken advantage of. Questions? I'm here.
Thank you very much for your testimony, Senator. Are there any questions from the committee? Senator, are you aware that there's a constitutional amendment in the House that does away with the Registrar of Probate?
I was not aware that they had one in there, but we have had similar ones both in the House and the Senate before, and also other legislation that would further go in and revise the statute. All of those have been turned down by prior legislators. So again, you know, the intent of the Constitution was to have a person, local person, that could provide assistance in the process, not in assistance in representing the person, so they could get through the process. And That's what I'm really asking for. It would be funded by that fee. So,
Okay, thank you very much, Senator. Any further questions? All right, seeing none, thank you. The chair will call Richard Head.
Good afternoon, Madam Chair, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. Judge King sends his apologies. He was unable to make it today. He would normally be here to provide testimony. Registers of probate, I did submit electronically a written testimony. It goes into far more detail than I will today, obviously, in terms of the history of registers of probate. They existed in order to run the probate courts, which previously operated at a local level. That is no longer the case. In 2011, the legislature restructured essentially the court system, created the circuit court, and within the circuit court created the probate division, the district division, and the family division. And all of those divisions now reside under the umbrella of the circuit court. The probate court, which existed previously, in which the registers of probate operated essentially as the clerks of, ceased to exist in 2011. Originally, that 2011 plan was supposed to be about a 10-year rollout. Significant financial considerations took place or kicked in, and the courts consolidated that 10-year plan into a 3-month plan. And in the course of doing that, reduced the number of clerks and registers from 52 to 18. The registers of probate were able to apply for those positions that were created as a result of the 2011 legislation. And since then, probate court has ceased to exist. And in that process, the role of the register of probate and the elimination of the role of the register of probate was made explicit. Judge King met with all the registers of probate and said the plan is to eliminate the role of the registers of probate. You do not have a role in, and in 2011, there was no testimony in opposition that was presented to either body. And in the course of testimony, at the time, Chief Justice Delanis said that the duties, and testified that the duties of the registered were pared back to essentially nothing. And that was the intent of the legislation in 2011. Judge King testified that the registers of probate would be responsible for the ancient record. He also said if they don't show up, that would be okay too, because essentially the clerks of the court are taking over all the roles. And that was throughout the entire process explicit. We've seen over the last several years many attempts to re-engage and recreate a new role for registers of probate. It's not the constitutional role. We do not have a probate court anymore. And what this does is creates a very confusing, potentially, situation where you have county registers of probate that have some active role. Courts are now collecting an additional fee from every filing. We then have to coordinate with each county to figure out how to distribute those fees to those counties based upon caseload that's being filed in those counties. The reality, though, and as is in the written testimony, the reality of the system that we've put in place is the vast majority of cases are being managed at Concord. It doesn't matter what county they apply in Concord. So for example, estates, about 3% of those cases require a hearing, which goes out to the local circuit court. And again, it's going to a circuit court. It's not going to a probate court. It'll be in the division, but essentially it's the same thing. Guardianships, 100% are handled initially in Concord. Name changes, 100% of those are handled locally in Concord. Trusts, essentially 100% of those are managed in the trust docket in Concord. Involuntary admissions, depends where the facility is, but we have the state hospital here in Concord, and a significant majority of those are handled here. And really the only thing that is handled in the circuit courts around the state are adoptions. The reality is registers of probate, experience, knowledge, or training in probate. They can be and frequently are just about anybody. Judge King would tell a story about having received a call from an individual who said, I was at a party, the guys thought it'd be fun if I signed up to be a registrar of probate and I won. What do I do? It's a job that doesn't exist anymore, and there's no need to recreate a job that doesn't have a need at a county level. We do have, and we have a very good call center, and we get just an incredible number of compliments about that call center. They are busy, but they are experienced and they are trained, and they know how to get people through the process of probate. And we receive compliments from lawyers and pro se individuals who are interacting with our call center. And lawyers who practice in the other New England states frequently say, I get more help from this call center than I get in any of the other states. It is a very effective and useful resource for those who are engaged in our process. In addition, we've been working on how to simplify the process. So we now have, and have since the beginning of 2020, a file and serve system, which is a more pure e-filing system. It's not just file a form. It's a self-guided process. So you go through a series of questions on that, and the person who is filing answers those questions, and those answers are what creates the filing. So it's a true self-guided file and serve electronic system. The other aspect of this bill is there's a recognition, apparently in the bill, that elected registers of probate really do not necessarily, and typically do not, I'm not saying all of them don't, some of them actually do have some knowledge, but you're likely to be electing somebody who people know in town, not because of their skill as a registrar of probate or their knowledge of probate. So it creates a new position, which has never existed before, the deputy registrar of probate, which would be presumably somebody the county hires who would then have knowledge of probate. And again, nothing is happening at that local level. So from an individual's perspective, it does create confusion. It's unclear as to exactly what they would do, and I suspect an awful lot of them will simply be calling the call center, asking for guidance. What we encourage and what we want people to do is go through our training materials online, go through the self-guided system, use our help center, for any assistance they may need, and keep it within the court system rather than creating this confusing two separate county-state system where the county doesn't have a role, but we as a state are somehow transmitting money to those counties in a way that really develops and creates more confusion. And as Senator Carson, as you mentioned, there is a constitutional amendment over in the House. There was a hearing on that, and if that crosses over, we would ask for support on the constitutional amendment. With that, I'd be happy to answer any questions, as long as they're not too specific about probate.
Thank you very much for your testimony, Mr. Head. Are there any questions from the committee? Senator Gannon, then Senator French.
Thank you, Attorney Head. Did you hear Senator Gray go before you?
I did.
So how do you answer him when he said there was no one, the clerk didn't really help him, the call center didn't help his daughter-in-law? Did they run into the wrong phone call?
It's difficult. I mean, I don't know, obviously, his particular case. We do, there are a couple things that happen. So he is correct. You don't get the same person every time you call, but every time you call, that person can pull up the exact same docket for that individual. So they have access to the documents, the docket, and what has transpired. They are also all trained in terms of how to get people through the process. And I see, people write and email and call the managers and say, it was so helpful that this person got me through the system. Whether or not there are particular instances in which there are problems, any system is going to have a defect, and it may very well be Senator Gray's family had a bad day. It is not the norm, and even through COVID, when we were remote, we set up a system where every one of them was doing the exact same job and had the exact same access from home systems. We created a system. In fact, the system was created by somebody, when I said in 2011, everyone who is in the system currently could apply for the jobs under the new circuit court system. One of the former registrars of probate was one of the people who set up the call line, and actually took that on and did an incredible job. So I won't say there are never defects. Obviously, there are. That is not the norm, and they do take a great deal of care in terms of ensuring that people get through. There are times, I will also note that the system is busy. So you do get, how long a wait you have. It does give you the option to leave a message. Every one of those messages is returned. And I think it is a good system. I won't say there are instances where problems don't happen, but the majority of that, I think that's uncommon.
I'm good. Thank you very much.
Thank you.
Senator French?
Thank you, Madam Chair. And thank you, Mr. Head. If we were to pass this, would that eliminate the call center, or did you say they would be competing?
I think, thank you for the question. It would certainly not eliminate the call center. What we're talking about is 10 people around the state and counties who would have some sort of undefined role, but it would not in any way, shape, or form change what we have. And it wouldn't surprise me if ultimately some of those new registrars of probate were using our services to be able to help their own constituents. So it would eliminate nothing on our end and would add a fee, would add a processing that we have to now, on a regular basis, identify what the pro rata share of funds is that would go to each county. It's unclear. We wouldn't set the fee or the pay for those registrars of probate. The $20, I think it's actually $20 in the bill, would, if you use the 2019 filing data, collect about $230 some odd thousand annually. Unclear sort of how that would get distributed, and if the county, and ultimately that was not a sufficient amount of money, the counties would be responsible for the rest of the salary. It's really a reimbursement to the counties, but would not change anything on our end.
Mr. Head, thank you for taking my question. Don't we currently have individuals that were elected in each county serving as registrars of probate?
Yes, so there are people with the titles of registrar of probate. They are elected every 2 years. They have no significant role. They have by statute, and the other aspect is the Constitution does not describe the role of registrars of probate. That's statutory. So by statute, they have a role relative to ancient records. That was modified a few years ago to make it more interactive with the Secretary of State to ensure sort of that the records are being transferred to the Secretary of State properly. It almost became more of an executive branch function in terms of the handling of ancient records, but that's their only role, and their salary was cut, and I can't remember what it is, but it's nominal. So it is largely a non-functioning role. But there are people with the title registrars of probate, and they're elected because the Constitution does provide for it, which is the reason for the constitutional amendment in the House.
Mr. Head, is there anything to stop someone who wants to contact their register of probate and ask for help?
Thank you. No, there's nothing at all that stops anybody from calling a register of probate and asking for help. Typically, it's more family members that provide the help. But there's absolutely no reason why somebody couldn't call their county register of probate and say, how do I do this? Chances are they're going to be told, I don't know. There are, and I say that facetiously, there are certainly some that do, and I don't deny that, but there are, even under the old system, some that did not, but certainly they could.
Okay, thank you. Are there any further questions? Okay. Seeing none, thank you very much, Mr. Head.
Thank you.
The chair will call James Monahan.
Thank you, Senator Carson, members of the committee. My name is Jim Monahan, and I'm with the DuPont Group, and we represent the New Hampshire Association of Counties. I'm here today in opposition to the legislation, Senate Bill 327. I'm going to give the committee a copy of a letter from the association which summarizes our opposition. But I think from the testimony you've heard from Attorney Head, it's clear that I think it was in 2011, the legislature rang the bell. And it's very challenging to unring that bell. And I think that's the problems that not only that we've heard from the court system, but from the counties as well, the complexities associated with standing up a parallel system or some other system. There are a couple other parts of the bill that I wanted to call attention to as well. First of all, if you read deep into the bill, well, and it's been addressed, it does create a new fee and a mechanism to collect the fee and redistribute it to the counties. The bill doesn't have a fiscal note. Normally, I would wait, assuming that those issues would go to the Finance Committee, but I don't know that this bill is headed there if it passes the Policy Committee. So I wanted to call that to your attention. It also sets up a mechanism for the counties to spend money to establish a salary for the registrar, which doesn't exist in their budgets today. And from our understanding of the information we've heard from the court system, the amount of money collected from the fee is very likely not to be sufficient for the salary and benefits for the registrar. So it will probably impose a fee on the counties for that. And then finally, it has not been addressed yet, but the bill does include a provision to have probate records transferred from the counties to the state archives. I wouldn't say that the counties or the registers of deeds have any significant, huge problem with that, but I would make sure that we address that with some care if we move forward, understanding that not every county is the same. In Rockingham County, for example, they made the investment to digitize all that information, whereas some of the other smaller counties have not. And so I think we want to be careful that we don't end up giving the Secretary of State and State Archives Office a messy bundle. This isn't fair, but a messy bundle of records to manage. There should be some order to that transfer, which I suspect would happen, but is not specified in the legislation.
Thank you. Are there any questions for Mr. Monahan? I just have a quick question. I noticed that the effective date would be January 1st, 2023. We've had this bell ringing for well over 10 years. Do you think that that's an adequate amount of time to go back to the old system, considering the fact that this is a piece of legislation and it probably won't get signed until June or July? It doesn't leave a lot of time to unring that bell and go back to the old way.
I totally agree with you, Senator.
Okay, thank you. Are there any further questions? Okay, seeing none, thank you very much. Are there any other members of the public who would like to speak to Senate Bill 327? Okay, seeing none, we'll close the public hearing. Thank you. You're all set? Okay. We're going to go ahead and open the next public hearing on Senate Bill 392 and call the prime sponsor, Senator Sherman. Good afternoon, Senator.
Good afternoon, Madam Chair. Thank you for the opportunity to introduce this bill, Senate Bill 392. For the record, my name is Senator Tom Sherman, District 24, representing 11 towns along the seacoast. And this bill is I find it really interesting, at both the bill, the subject, and the natural history of this bill from where it started. The bill started in 1918. I wasn't around then. But that's when the state last revised its definition of insane. And I'll read this to you. You'll understand why it's probably a good time for an update. The definition of insane has not been amended since 1918. Currently, RSA 21:18 states, the words insane or insane person shall include every idiot, non-compos, that's NONCOMPOS, lunatic, insane or distracted person. That's in our statute. Yeah. And so it seemed fairly straightforward when the Department of Health and Human Services came to me and asked me to put in a revision to this, which you have in the actual text of the bill. But what I'm asking the committee to do today is to reconsider that. Last fall, as a part of my work on the Governor's Advisory Council on Mental Illness in the Corrections System, working with Commissioner Hanks of the Department of Corrections, we identified that there are significant issues in the state with competency and restoration, which seems to go sort of hand in hand in some ways with the intent of this bill. And then more recently, like in the last 48 hours, we were made aware by the Department of Justice that this could put in jeopardy cases that are currently pending in the court system. So what we would ask the committee to do would be to consider allowing me, and we've talked a little bit about this, to propose a commission staffed by the Department of Corrections to examine both this definition and the issues of competency and restoration in the state of New Hampshire. And I'll just quote from an email from the Commissioner of Corrections, Helen Hanks. It's not her words, but it's Dr. Shannon Bader wrote this. The number of defendants ordered for competency evaluations has increased substantially over the last 5 years, with some states reporting 70 to 100% increases. That's huge. New Hampshire has experienced a 75% increase in the number of competency orders since just 2015. With increases in the numbers of competency evaluations, there are more individuals court-ordered for competency restorations. Numerous states have endeavored to reform the competency restoration systems as states face lawsuits and legislatures desire to save money and protect community safety. So the interesting part of this is the members of this commission, which are proposed as members of the legislature, both House and Senate, the Attorney General or designee, member of the Defense Bar, designee from county attorneys, Department of Corrections Commissioner designee, DHHS Commissioner designee, and several others, would be looking at both issues. So this would create, and I can probably have that ready for you as an amendment within a week or so, a commission that would tackle these issues and be able to hopefully address both this, I think, blatantly archaic definition, but also the problem of increased competency and restoration issues in the state. So I'd hope that you would accept that request and be willing to think about moving forward with the commission.
Thank you very much for your testimony, Senator. Are there any questions from the committee? Seeing none, thank you.
Thank you.
The chair will call Jeff Streslin.
Thank you. Good afternoon. My name is Jeff Strelzin. I'm an Associate Attorney General from the Attorney General's Office.
Here to answer any questions you have, we would support the proposed amendment to expand this to a study commission and look at all the various facets, not just the insanity piece, but also the competency and restoration piece as well. We think that does make sense.
Okay, thank you very much. Are there any questions from the committee? Okay, seeing
Thank you
none,
very much.
Thank you. The chair will call Dr. Daniel Lampiano.
Good afternoon. My name is Dr. Daniel Alpignano. I work at New Hampshire Hospital. I'm a forensic psychiatrist there, and I represent Department of Health and Human Services in support of this bill and the amendment that the senator has just proposed. We know that I, in my daily work with forensic patients and encounter issues that relate to both the NGRI population and the incompetent to stand trial population that we serve. We know that there are many different issues that the state faces regarding both of these populations, and we think, a lot of work to do to try to improve our handling of those patient populations. That's all I have to say, and happy to answer any questions.
Thank you very much for your testimony. Are there any questions from the committee? Doctor, do you support a study commission?
I do, absolutely.
Okay. Thank you very much.
Thank you.
Okay, next, it looks like two individuals would like to come up together. Looks like Melissa St. Cyr and Andrea Muchek.
Thank you, Senator.
Good afternoon.
Hello, good afternoon. For the record, my name is Melissa St. Cyr. I'm the Chief Legal Officer for the Department of Health and Human Services. And with me today?
Dr. Andrea Machette, so good attempt. I'm the Director of the Forensic Program at New Hampshire Hospital.
And we want to thank you all for having our testimony, and thanks, Senator Sherman, for bringing this forward. We do believe that it is very important. Clearly, the definition of insane as it is in our statutory construction in RSA 2118 is offensive and certainly needs to be updated. And so we're very happy to move this forward. We do want to work. We've had some conversations with the Department of Corrections, the Department of Justice, with Senator Sherman around an amendment that would bring forward a commission to study not only the definition of insane, but also restoration and competency. And we support both of those as well. I'm happy to answer any questions you have, and also Dr. Machette can also.
Thank you. Are you all set? Did you had any, was there anything you'd like to add?
No, ma'am.
Okay. Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you.
So much.
Okay, next we're going to call David Goldstein. Good afternoon, Chief.
Good afternoon, Senator Carson, members of the committee. For the record, my name is David Goldstein, and I'm the Chief of Police for the City of Franklin. And I honestly feel like I'm in a graduate school class right about now with the preceding individuals. I've been a police officer for more than 42 years, and I'm the chair of the New Hampshire Association of Chiefs of Police Legislative Committee, and I'm here to testify in opposition to Senate Bill 392 as written. And I want to underscore that, as written. I hold a bachelor's in psych, a master's in public health with a concentration in mental health issues, and a PhD in counseling and human services. I'm board certified in forensic traumatology by and with the fellow and diplomate of the American Academy of Experts in Traumatic Stress. I've conducted empirical research in such areas as suicidal ideation among disabled veterans and the delivery of services for law enforcement officers who have experienced stress and trauma. I've written a number of peer-reviewed articles as well as articles for trade-related magazines in these areas. The bill as written just presents a number of conundrums and questions. And listening to some of the previous testimony, it's very true. This was the DSM-2 when I started my graduate work on, and the Diagnostic and Statistical Manual of Mental Disorders, published by the American Psychiatric Association. This is the DSM-5, this many years later. Same book, if you will, same publication, same publishers. The point being that we have obviously evolved a great deal in this area, and we should continue to do so. But we have to ask, what does it mean? What do some of the terms in this particular bill mean as far as insane or insanity? Included here, we have to ask ourselves, what does the word suffer mean when one suffers from a particular condition? Well, in the 1980s, before the ICACs, et cetera, I spent 2 years investigating crimes against children, including sexual assaults against children. And I investigated a number of those cases and interviewed a number of pedophiles. And I'm going to tell you right now, they were not suffering from their disorder. Now, I realize today it's changed, but then it was considered a personality disorder. They weren't suffering. They were more upset about the fact that they got caught by law enforcement than they were that they had hurt children. Perhaps a more philosophical question, but applicable to the bill as well, is who defines reality? And by way of example, I'd like to offer an experience I had during a clinical externship at St. Elizabeth's Hospital in Brighton, which was a Tufts Medical School affiliate. And we were in an intake interview with a young woman who was diagnosed at that time as schizophrenic, paranoid schizophrenic. And her story was that she, her husband, their dog, and their son had moved to Canada to join a commune. And while they were there, the leaders of the commune had separated the family. They took her husband away, they took her child away, they killed the dog, and they used her for sexual favors. And of course, as we were sitting in this interview conducted by the chief of psychiatry at the time, we were all sitting and saying, this lady's crazy. Until a week later, the Guyana story broke the news in Time magazine. And I'm not sure how many people in this room remember Jim Jones and the 999 people who drank the Kool-Aid. And all of a sudden, I began to wonder, what was the reality here? Was that lady that we had all said was a little bit off her nut, was she really crazy? Who diagnoses these conditions? Who's going to make these final determinations? Psychiatrists, clinical psychologists, licensed clinical social workers, licensed mental health practitioners, advanced registered nurse practitioners in psychiatry? I'm not sure. Are these diagnoses open to interpretation by clinicians? There are often conflicting opinions within this realm, as we all know. And I'm sure that the prime sponsor has experienced such disagreements in his medical practice. And these are just a few of the questions that rise immediately to the surface concerning this bill. As I've heard so many times over the past 13 years that I've been testifying both here and in the LOB, this bill isn't ready for prime time. Of course, we are more than willing to assist with any study committee or commission should that be the chosen path. And we would like a seat on that, at that table if it's at all possible. However, if nothing else, this bill, we feel, should be ITL'd. Thank you, and I'll take any questions you might have.
Thank you very much, Chief. Are there any questions from the committee? Senator French.
Good to see you, Chief.
Same here, Senator.
Would you be willing to sit on a commission like this?
Absolutely.
Great, thank you.
You're welcome.
Nice.
Okay. Are there any further questions? Okay, seeing none. Thank you very much, Chief. The chair will call Shannon Bader.
I'm going to provide a copy of the written testimony for the bill as stated.
Yes, please. Thank you.
Madam Chair, Commissioner Hanks, and Dr. Bader is one of my fine contracted employees. So,
Okay.
and as Senator Sherman referenced, I also, for the record, Helen Hanks, Commissioner of the Department of Corrections, I shouldn't get ahead of myself. I'm passing out a report from the Governor's Advisory Commission on mental illness in the correction system. It's our most recent report from this past November. And if you go to our external webpage to the Commissioner's office, you can see the work of that commission and the relevance of the conversation today.
My name is Shannon Bader. I'm the Chief Forensic Evaluator for the state of New Hampshire. Our office is responsible for conducting all of the evaluations for the criminal court system, including insanity evaluations, as well as competency evaluations and restoration evaluations.
Thank you.
I'm also the president-elect of the American Academy of Forensic Psychology. We want to speak in support from the Department of Corrections for the study committee. Senator Sherman was nice enough to read some of the language that I provided before about this topic. We agree that there needs to be a change in both the definition of insanity in the state. We also want to discuss the importance of restoration and competency in the state of New Hampshire. Currently, right now, our numbers have increased, but as of right now, in New Hampshire, folks that are found not ready to go to court have a year to get better. Only about 40% of them are actually getting better. So folks that could be found competent and move through their criminal process are not having the opportunity to do so because of the lack of treatment, resources, and a structured environment to do any competency restoration. This leads about 60% of folks that could be restored to competency not available to go to their criminal court process. In our opinion, this leads to a dearth of justice for both the victims as well as the defendants who don't get their day in court. Our state numbers, this 40% number that's just been stable since I became chief in 2015, is remarkably less than most other states. Most other states report an 80% restoration rate. Right now, we're also one of the only states that doesn't have a formalized restoration process. The courts will order someone to go into restoration services, but that means they're on their own to find and secure those mental health services. These are folks that have been found incompetent to be able to participate in their own trial, but yet they're expected to navigate the complicated mental health system on their own. So in sum, thank you for your service to the state, and the Department of Corrections does support the study committee.
Okay, thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you very much. Are there any other members of the public that would like to speak to Senate Bill 392? Okay, before we close the public hearing, I know Senator Sherman, you and I have discussed bringing together the commission, and I am hoping that you can get us the language by February 22nd. Sure. Okay. Okay, we're going to go ahead and close the public hearing on Senate Bill 392. The room is going to clear. Okay, Jen, I'll come by. Bill, you get to do the honors again? I think we're good on time.
Senate Judiciary is back in session. The Honorable Rory Cornell is introducing 388.
Thank you very much, Mr. Chair. For the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14, comprising the towns of Hudson, Londonderry, and Auburn. And I have for your consideration this afternoon Senate Bill 388, an act relative to availability of information or records relating to the enhanced 911 system. This bill exempts certain information obtained through the enhanced 911 system and uses in insurance fraud investigation from the right to know laws. I'm introducing Senate Bill 388 at the request of the Insurance Department to allow their insurance fraud unit access to those relevant recorded 911 calls that will facilitate the investigation of insurance fraud cases. The department has conferred with both the AG's office and the Department of Safety, who have given their approval of this proposal, and the insurance industry is in very much support of the bill. Brendan Harris from the Insurance Department is here to explain the need for this legislation and to answer any questions the committee may have. Thank you for your consideration of this legislation.
Thank you, Senator Carson. Does anyone have any questions? Seeing none, thank you for your testimony. Brendan, do you both want to come up together? Or? Great, thank you. State your names.
Good afternoon. I'm Heather Silverstein. I'm General Counsel for the New Hampshire Insurance Department.
And I'm Brendan Harris. I'm the fraud examiner in charge at the New Hampshire Insurance Department. I manage the fraud unit. Senator Carson, committee members, thank you much for having us for a few minutes. We're trying to introduce Senate Bill 388 to try to get some records from the 911 system when we have open criminal investigations. Just in case anyone's unfamiliar with the insurance fraud unit, it's strictly a criminal investigations unit. So we only work insurance fraud or insurance-related criminal activity cases. The statute as it's written now, it allows for the release of 911 records to law enforcement agencies, but the insurance fraud unit is not technically a law enforcement agency, so we're barred from receiving those records as the way the statute's written right now. So we're trying to change some of that language to allow us to collect some 911 records when we feel like we might need them, and it just helps bolster our criminal case as we go forward. So that's the real intent behind asking for this bill to be introduced. We've met with the New Hampshire Attorney General's office. Eddie Edwards is the Deputy Director or Deputy Commissioner for the Department of Safety, and Mark Doyle, who's the Director of the E911 system. We've explained our position there, and that we promised that we, by statute, would be keeping all their records in confidential. They wouldn't be released by subpoena or any other way. So if we can have the records, they will stay with us secured for 6 years, at which point we destroy all records after 6 years, so those records then would be destroyed. The only time these records would ever be released is in any criminal case with discovery. If we indicted somebody, then we have to release everything that we have. That's just required. And so that would be the only time that one of those 911 calls might go to a criminal prosecutor. But short of that, we probably would only be asking for these records maybe a half a dozen times a year, and so it's not a big request. It won't be like time-consuming for someone over at the 911 system to be developing and copying these 911 calls. It would be very limited in our request. But in short, that's pretty much the reason we're asking for this bill.
And as a follow-up to this, as a head of legal, I am involved in the right-to-know requests that come to our office. So I know these types of records would never be disclosed. They're confidential, and it would be something that we would not just disclose to the public. So they couldn't, in a roundabout way, try to get them from us once we receive the records as a right-to-know request. And then as far as our fraud unit goes, we're a little unique in that, normally the insurance department does regulatory work. We're not considered criminal, but our fraud unit is a criminal type unit, and then they investigate criminal insurance fraud, and then once the case has come to a point where we think we have a good case, then we work with prosecutors like the AG's office or county attorneys, and so that's how we kind of coordinate with the law enforcement agencies. And so this is why it's neat for us. It's needed to have this sort of access to those 911 records.
And just a quick follow-up, there is a statute specific to us collecting records. It's a RSA 41729, and that's what specifically says, in short, what comes into the fraud unit stays in the fraud unit. You can't get it through subpoena, you can't get it through any other way. So when it does come in, we will keep it secure and keep it confidential.
Okay, are there any questions? Okay, seeing none, thank you very much.
Thank you very much.
Thank you.
Okay. Next we have, it looks like Robert Lussier, and is it Mark Doyle?
Yes.
Okay, I wasn't sure if it was Mark. Looked like it. I'm not
It is
sure.
Mark, and thank you.
But does Mr. Lussier wish to speak as well?
Mr. Lussier was going to speak on my behalf. I had another
Okay,
matter I was
so-
going to be jumping across the street to, but as it worked out, you
He
folks are
doesn't-
far more on time than the folks across the street, so.
Okay.
And that's not a disparaging comment, by the way. It just is what it is.
Okay.
I just wanted to bring to your attention our perspective at the Department of Safety relative to the discussions we've had with the folks from the Department of Insurance regarding the proposed amendment to RSA 106H. And obviously our impact was when it came to the information that we were going to be provisioning to the Department of Insurance for the purposes of conducting fraud investigations was the confidentiality associated with all 911 records, not the least of which are 911 recordings, which we have taken a great deal of ownership of and maintained very strict control relative to. And we want to make sure that moving forward, whatever changes are made, that those controls remain intact and in effect either on our side of the house or wherever they may end up. Having a lot of discussion with the fraud investigator from the Department of Insurance, Brendan Harris, as well as Attorney Silverstein, have been assured that those protocols will remain in place in full force and effect by virtue of anything other than the fact that they're not a law enforcement officer, which currently provides for the dissemination of those records to bona fide law enforcement agents in statute. The same protocols are in effect in the sense that they have to work closely hand in hand with the Attorney General's office when it comes to conducting any criminal investigation. So insofar as the law enforcement component is complied with, if you will, we feel comfortable that the Attorney General's office will have oversight over those investigations, at least to the degree that they'll be put on notice that they're being conducted. Insofar as the confidentiality of the materials that we provision to them, it looks like, and I've been assured by my own viewing of and by the information provided by Attorney Silverstein relative to the RSAs that are currently in place, that those materials will be safeguarded in so much as the way that they are currently safeguarded in an evidentiary protocol process whenever we provide them to a law enforcement agency conducting an investigation. And so far as there's not going to be any ability for anyone to obtain access to them through a Freedom of Information Act request or a 91A request, those protocols and safeguards are in place as well. So from our perspective, we take no position on the bill other than we've had some great conversations with the folks at the Department of Insurance to assure that the confidentiality remains intact and in effect.
Okay, thank you very much for your testimony. Are there any questions for Mr. Doyle? Okay, seeing none, thank you very much for your testimony.
Thank you, ma'am.
Are there any other members of the public that would like to speak to Senate Bill 388? Okay, seeing none, we'll close the public hearing. It is 2:30. The committee will be in recess until 2:45. Can you believe it? It's 2:30. We're done. You're not leaving, are you? No, I'm just gonna. I hope he's back so that we can exec.
Yeah.
Pardon?
I'm just gonna check on Jay.
Where is he?
He can't do what.
Oh, okay. Thank you, Jen.
You're coming back, right? Yes, coming back. Okay, good.
Yeah. No, I asked.
2:45.
Yep.
Just taking care of my hair. It's stressing me out. Well, no, and we have things that we're going to accept. Okay, perfect. Sarah Carson, just a heads up, your mic is still on.
Okay, the committee will come out of recess. Is there a motion to go into executive session?
So moved.
Okay, Senator French moves to go into executive session, second, Senator Whitley seconds. Okay, all in favor say aye.
Aye.
Aye. Any opposed? Okay, I'd just like to talk briefly about the bills we had today.
Yep.
And see if there's any of them that you would like to exec today. Let's see, the first one is requiring notice of arrest to a probation and parole officer. I think this one might need a little bit of work, so I don't believe this one's ready to go. The next one is Senate Bill 327, an act relative to the duties of the registers of probate. I'd like to exec this one today. We get this one, and this, quite frankly, is a refile of one that was done a few years ago. Does everyone want to do this?
Sure.
Okay. Okay. Is there a motion on Senate Bill 327?
I move ought to pass on Senate Bill 297.
You want to pass it?
Think about that.
327, Jay.
The registers of probate?
No, I thought we were on 397.
No.
No.
327.
297.
Nope.
You don't want to take that up? Yeah, that's okay.
I'll
Okay.
second that motion.
No, I don't, I would
Okay,
move.
all right, let's hold on
Yeah.
a second here. There's some confusion. We're taking up Senate Bill 327, an act relative to the duties of the registrars of probates. Is there a motion?
Motion for ITL.
Okay, motion, is
I'll
there a
second.
second? Okay, moved by Senator Gannon, seconded by Senator Khan. We've had this bill a number of times in one form or another. We do have our registers of probates. They are elected officials, but they have very circumspect duties. This would be expanding their duties once again. We went through all of this change, as Mr. Head from the Department of Justice talked about. Why are we going to roll it back? It's working. You might have a few bumps here and there, but for the most part, it is working. And I think it would be a huge step backwards to go back to the old system. Plus, there's a constitutional amendment in the House doing away with the office altogether. So for that reason, I will support the ITO. Are there any other comments, any other questions? Okay, seeing none, all in favor say aye.
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 Any opposed?
No,
Okay. Okay,
I'll take it out.
no, you ain't taking it.
I
You
guess
can't
not.
do that, Senator French. Okay. Okay, and this is ITL, 4-1. I'll take this one out, Jenny. Okay. Next, we have, we discussed Senate Bill 392. This one is relative to the statutory definition of insane or insane person. Senator Sherman is going to be working on an amendment to turn this into a commission, and there is a consensus and support on turning this bill into a commission. So we will wait till we get the language from Senator Sherman. Next, we have Senate Bill 388, an act relative to availability of information or records relating to the enhanced 911 system. What do you folks want to do? Do you want to exec this one today, or do you want to wait? Okay, it seems yes, yes, yes.
Sure.
Okay. Okay, is there a motion on Senate Bill 388?
Move ought to pass.
Okay, Senator Khan moves out to pass. Is there a second?
Sure.
Senator Gannon. Okay, I think the bill is pretty self-explanatory. The Department of Insurance wants to be able to get access to these records for insurance fraud claims. They did tell us that they hold the records for 6 years and that the records are protected under, I forgot what the RSA number is, I wrote it down, under RSA 41729, so they're not subject to the right to know law. So, are there any further comments, any further questions? Okay, seeing none, all in favor say aye.
Aye.
Aye, any opposed? Okay, is there a motion for the consent calendar?
So moved.
Moved by Senator Whitley, is there a second? By Senator Gannon. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? And Jenny, I'll do this one because it's my bill. Okay, now we're going to take up the others. The first one we're going to take up is Senate Bill 291, an act establishing a committee to study the issue of unmarried cohabitants, domestic partnerships, and common law marriages.
I move OTP.
Okay, Senator Whitley moves ought to pass. Is there a second?
Sure.
Senator Gannon seconds. Is there any discussion on this? I think it's pretty self-explanatory. It's a study committee. We do have people that enter into all kinds of partnerships, and I think it's a good idea that we take a look at that. Okay, we have a motion of ought to pass. Is there any further discussion? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Is there a motion for the consent calendar?
So moved.
Moved by Senator Whitley, seconded by Senator Gannon. Is there any discussion on the consent motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Who would like to take this one?
I can take this.
Okay. Okay. Next, let's see, we have Senate Bill 296, relative to complaint procedures in cases before the Commission on Human Rights.
Move ought to pass.
Second.
Okay, Senator French moves ought to pass, seconded by Senator Whitley. Is there any discussion on the bill?
I think this bill makes a lot of sense. It's been heard before. I think that, we have an excellent Human Rights Commission, and there was compelling testimony that this would be a good thing. So I'm in strong support of it.
Okay. Any further comments? Any further questions? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Is there a motion for consent?
So moved.
Moved by Senator Whitley, seconded by Senator Gannon. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay, who would like to take this one out?
Jenny and I can take it out.
You want to?
Sure. It's my
Okay.
bill.
This bill?
Oh, that's right, I forgot.
Sorry.
It's been a long afternoon,
Jenny.
Senator. The next one we can take up is Senate Bill 336, an act relative to family mediator interns. Is there a motion?
Ought to pass.
Motion of ought to pass. Is there a second?
Second.
Seconded by Senator Whitley. Is there any discussion on the ought to pass motion?
Do we have an amendment coming on this one? This is the one that Honey Hastings,
Yes, there is an amendment. We're going to have to hold off on it.
Okay.
Sorry.
There was a little, as Rick can help us, there was a little confusion between, is there one amendment or is there two amendments? So let's circle up about that.
There's two
Okay.
that we can combine into one.
Okay,
And I have it
perfect.
right here.
Okay,
It's the
great.
first one. So
Okay.
we'll have to wait on this one. So Senator Gannon, will you withdraw your motion?
So withdrawn.
And Senator Whitley?
Yep.
Okay, so we have to work on that, get that amendment. Okay, next, we have Senate Bill 342, an act relative to the minutes of non-public sessions under the right to know law.
Move ITL.
Second.
Okay, we have a motion of ITL, moved by Senator French, seconded by Senator Whitley.
I don't want to say anything except,
I think that this bill needs a lot more work.
I agree.
And we'll just leave it at that.
Yeah.
Okay.
Yeah, I would just say that, this area of law is certainly worthy of discussion, but we have this balancing test, weighing public interest against, so transparency, and I think the courts are doing an excellent job. These are nuanced determinations that are better left, I think, within the municipalities rather than categorically in statute. So I think this is a smart move.
Okay. So we have an ought to pass motion. Is any?
no, ITL.
Oh, no,
ITL.
excuse me, ITL. So it's getting late. Okay, we have a motion for ITL. Is there any further discussion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay.
Move consent.
Okay, Senator French moves consent calendar. Is there a second? Second by Senator Gannon. Is there any discussion on the consent calendar motion? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Who would like to take this one out?
I can.
Okay. Okay. Next, we have Senate Bill 393.
I move OTP.
Okay, we moved to pass by Senator Whitley, seconded by Senator Gannon.
And I would like to introduce Amendment 0125 and speak to my amendment, if that's okay?
Sure.
This is the amendment that we worked very closely with Commissioner Hanks to truly align her practice with the bill. And so we're incredibly grateful for her support and her work to get this bill in a place that is really workable. And I think the biggest thing that we're trying to accomplish here is balancing the safety of moms and babies with public safety and the safety of correctional officers. And I think we heard ample testimony that this amendment does that. So hopefully the committee can support the amendment. So I'd move OTP on the amendment.
Okay, so we have proposed amendment 0125S.
Move on to pass on the amendment.
Okay, Senator French moves on to pass on the amendment. Is there a second?
Second.
Seconded by Senator Whitley. Okay. Is there any discussion on the amendment? Seeing none, all in favor say aye.
Aye.
Aye. Any opposed?
Move on to pass on the bill as amended.
Second.
We have a motion of vote to pass as amended. Moved by Senator French, seconded by Senator Whitley. Is there any discussion on the bill as amended?
Great.
No? No comments. Okay. So we got the ought to pass as amended motion. All in favor say aye.
Aye.
Aye. Any opposed? Okay, is there a motion for consent?
I'd like to touch base on the floor on this
Okay.
issue, yeah.
Then I'll like to change my vote if she has to talk about it.
Unbelievable. I am going to make my floor speech 3 minutes longer, Senator French, just because of that comment.
That one was coming.
And I'm going to stand up and I'm going to give it to you.
Okay, we're just gonna, let's see. The next one, and I didn't know how you folks felt about it. Senator Whitley, yeah.
Yeah, of course.
Senate Bill 431, an act relative to child support in cases with equal or approximately equal parenting schedules.
I move OTP.
Okay, so we got
431.
431. So we've got ought to pass motion moved by Senator Whitley, seconded by Senator Gannon.
I'll speak to that
I didn't know
motion.
how you both felt about it because, this issue tends to be a little, as you can see, a little contentious. We had a lot of testimony from people that are paying child support who are not happy. But I think Ms. Hastings and the study group did what we asked them to do last year because we did have a couple of bills that we got from the House dealing with this particular issue, and they came forward and they offered to convene a study group, and this bill is the result of that study group. Senator Khan?
I'd like to propose a committee amendment to change the effective date to January 1st, 2023.
Okay, what is the effective date now?
June 30th, 2022.
Okay.
And the judicial branch requested that be changed to,
Okay,
and I'll
right.
second that committee amendment.
Just
Okay.
staying on top of things here.
You are.
Yeah, they are. That's good.
Madam Chair?
Yes.
So, I think too, I agree this is a difficult issue. A lot of families are really struggling with it, but I also feel like the Child Support Working Group has some of the smartest lawyers
I know.
here, right, in the state who are very thoughtful in balancing the interests between children and parents. And so I think them working through these issues and coming to us with a very fully baked proposal is something that we should definitely support.
Okay. So we have a proposed committee amendment changing the effective date to
2030.
Oh my God, don't listen to him.
January 1st, 2023.
Correct.
That's
So
correct.
Jenny will get that for us. So, okay, January 2023.
I'm
Okay.
glad my hearing aid works well.
Yeah.
That's why Senator Khan, we had to sit over there because that sound travels so much easier.
It does, and for the record, I don't have one.
I know you don't. Okay, so we have the proposed committee amendment. Is there any further discussion on the proposed committee amendment? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Okay, 5-0. Okay, we need, is there a motion?
I move OTP as amended.
Okay, Senator Whitley moves ought to pass as amended. Is there any seconds by Senator Gannon? Okay, is there any discussion on amendment? I think we've talked a little bit about it, and we've all agreed it is a difficult subject, but the working group did a great job on coming up with these guidelines.
I think they did a great job, but I don't think they did a great job, so I'll be opposing this. This is a one-size-fits-all piece of legislation. It's difficult for me to digest in the form it is.
Okay. Okay, so we have a motion of ought to pass as amended. Is there any further comments? Seeing none, all in favor say aye.
Aye.
Any opposed?
No.
Okay, and I will take this one out, Jenny. Okay, next we're going to take up Senate Bill 399. We have an amendment. It is amendment number 0295S.
I move OTP on the original bill.
Okay, so there's an ought to pass on the bill.
So parliamentary inquiry?
Yeah.
So if I want the amendment, I should vote down the ought to pass now?
Well, we need to have a motion on the bill
First, okay, I'm sorry.
first.
Yep.
I'll
So,
second that.
okay.
Okay, that's
All
fine.
right, so, what we have is the amendment that was passed by the House, and it really, what it does is, it deals with the ultrasound provision, which tended to be very controversial in the legislation that was passed earlier this year. And what it says is this subdivision shall be construed to require the performance of an ultrasound only if the provider either knows that the fetus has a gestational age of at least 24 weeks or is conscious of a substantial risk that the fetus has a gestational age of at least 24 weeks. We want to make sure that we address this particular issue of the ultrasound. There's no guarantee that the House is going to pass what this is, but this is what came out of the Judiciary Committee in the House. So we want to just have something just in case something should happen to it. But we certainly want to address the ultrasound issue. Senator Whitley?
So I just want to make sure everyone has the amendment, because I know it was emailed shortly before committee. So.
Yes, I do not.
I've seen it. Yep.
Could I get another copy, please? Thank you.
I'll take another one just in case I lost it.
You could leave one behind.
Don't trip on those cords. Thank you, sir.
I've got mine. Yeah, I got mine here, so we're good. Okay, Senator Whitley, you had a.
The testimony in this bill, it was lengthy, and we heard a lot of testimony last year also. And I have to say that I fully support the bill as drafted, a full repeal. And I think if that's not possible, then the next step should be to look at what the governor proposed. And the governor proposed in a letter to the House Judiciary, making sure that we're addressing the ultrasound issue, but also these difficult exceptions that we have discussed. That the bill or the law as passed does not have an exception for rape or incest. It does not have an exception for fatal fetal anonymity. So, if we can't go full repeal, we absolutely need to be responsive to the constituents that testified about these very difficult situations, and also what the governor has proposed. What is he going to be able to support? So I can't support this amendment because I could never support an amendment that doesn't have an exception for victims of rape or incest. I could never support an amendment that doesn't have an exception for a fatal fetal anomaly. And I certainly couldn't support an amendment that doesn't have eliminate criminal penalties. I think we have to listen to our medical providers, and we heard significant testimony for our medical providers that when abortions happen later in pregnancy in New Hampshire, they are only because of complicated and devastating situations. We also heard testimony from our highly qualified OBGYNs. I think they were very impressive. They are especially our Dr. Cass, who leads the teaching program at Dartmouth, a world-renowned OBGYN program. And what she said, that inclusion of an exception where a fatal fetal anomaly is discovered after 24 weeks, and that a 24-week bright line does not align with what we know, what the medical professionals are telling us about what the definition of viability is. We heard time and time again from these folks that viability is different in every pregnancy, okay? There is no way to draw a bright line in every single pregnancy about what is viable. It may be that 24 weeks is, viability in one pregnancy, but not in another. So we need to be listening to our providers when they tell us that there is no bright line here. And I also think we heard, that based on that definition, that medical definition of viability, that makes our existing law inconsistent with Roe, right? Which is the prevailing law of the land for the time being. Roe v. Wade says nothing about 24 weeks. Roe v. Wade talks about viability, right? So failure to have a fatal fetal exception is inconsistent with Roe v. Wade, which for right now is the law of the land. So I think the other point that we heard from providers is that failure to add this exception for a fatal fetal anomaly, failure to eliminate criminal penalties for New Hampshire doctors puts an already fragile system. We have heard, and I'm on Senate Health and Human Services, we have heard bill after bill after bill trying to address our very struggling maternal health system. We have deserts all across the state. We heard today from public health that women are having babies in cars. Women are having babies on the side of the road because we don't have adequate access to maternal health. We don't have adequate access to the services, basic services for women to have babies safely. So why would we do something that does nothing to address an already fragile system and that does nothing to mitigate this issue that we heard again, time and time again, about provider recruitment? Now, I wanted to sort of discuss an issue that we talked about with provider recruitment, and that's California. And I think the question was raised about, look, California has an abortion ban, and they don't have a problem recruiting folks. But I think it's important to point out that we heard this from Dartmouth. California's law pertaining to abortion is very different than New Hampshire's, and it's different in two significant ways. California's limitation on abortion does not rely on a fixed gestational age as it does in New Hampshire. In New Hampshire, it's 24 weeks. In California, it's based on viability, which again is based on Roe v. Wade, and it aligns closer with the medical definition of viability. So in California, it's a medical provider that determines viability, not politicians. And so I think by definition, California law prohibiting abortion after viability would not be applicable to a non-viable pregnancy. So that means in New Hampshire, a lack of a fatal fetal exception, is inconsistent here with this viability issue. So I think failure to pass 399 as drafted, robs women in unimaginably difficult circumstances. I'm a mom. I have been pregnant. It's a difficult, fraught time. I think it robs women in these unimaginably difficult situations the ability to make an informed decision, a healthcare decision, in consultation with their provider, and that works for her own family. And I think we're robbing her of that decision, and we're robbing her of the care in her very own home state. So I cannot support this amendment for all those reasons, and I hope that the committee votes it down. Thank you.
Thank you very much, Senator. Are there any further questions or comments? Okay. Seeing none, we have Senator Khan, do you have?
I just wonder, I certainly think that Senator Whitley has put together a pretty cogent argument in support of an ought to pass. I don't know that this amendment is consistent with that motion, so whether you want to introduce that here or...
Well, I believe we already, okay, so we got started talking about this before. So, okay, so we have amendment number 0295S. Is there a motion?
Move on to pass on amendment 0295S.
Okay, and is seconded by Senator Gannon. Okay, so are there any further comments, questions about amendment number 0295S? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed?
No.
Okay, Senator Khan, did you say yes?
I'll
Of course
say
he
no.
did.
I'm sorry?
No.
Okay, I didn't think so. Okay. So there is an ought to pass motion on Senate Bill 399 as amended. And that was moved by Senator Whitley, seconded by Senator Gannon. Senator Whitley? Oh,
No,
no, Senator Whitley moved ought to pass on the bill before the amendment. And that was the underlying motion. We had to have a motion to bring the amendment forward.
And so what some committees do is they take that ought-to-pass motion, automatically turn it into the OPA, and just take a vote. We take a different approach and request a new.
I move on to pass as amended.
Okay, ought to pass as amended, seconded by Senator Gannon. Is there any discussion on the bill as ought to pass as amended? Senator Whitley?
I have to express my concern again. We are not listening to our medical professionals by, failing to add the fatal fetal exception, by failing to add an exception for rape or incest, by failing to remove criminal penalties. And certainly, I think, we need to discuss this on the floor, so I'll be voting against this.
Okay. Are there any further comments, questions? Okay, seeing none, we have an ought to pass motion on Senate Bill 399 as amended. Okay, all in favor say aye.
Aye.
Aye. Any opposed?
No.
Okay, 3-2. And I guess I will be arguing this one too. Okay. And we have Senate Bill 436.
I move ought to pass.
Motion to until?
Okay,
Second.
okay, wait a second, hold it. Okay. I heard ITL, I heard a second, and I heard ought to pass.
And you heard ought to pass first.
Her left ear is stronger, so.
Well, I got a second over here, so, of an ITL motion. So the pending motion is ITL. So is there any discussion on the ITL motion? Senator Whitley?
So I think that, what I want to say is that if you, in reading this bill, which let's be clear, I support a full repeal of the Fetal Protection Act, but this bill leaves that in place. And this bill leaves that 24-week ban in place, okay? So this bill is looking at access to abortion from up to 24 weeks. I just want to make that clear. And Senator French is looking at me cross-eyed. But if you look at the bottom of the bill, it specifically protects access to abortion except as existing law. An existing law has an abortion ban after 24 weeks.
Senator French, you have a...
I can keep going.
Question, if you vote to pass this, you're voting for the bill that we just passed, aren't you?
No, bill that was put, the language that was put into the, that was put into the budget.
Right, so
Senator,
to support this, you're supporting that language.
No, if you look, Senator, if you look at line 9 of 436, okay, so the first part of the bill says, you can't restrict access, and then except as provided in 329, 132, and 132, two separate sections of 132. That's the existing abortion restricting, including the 24-week ban.
Right.
So this bill provides right to access to an abortion up to 24 weeks. Okay?
Which we have in law.
So that's the point here. I think what's important to understand is the state of affairs right now in access to abortion in New Hampshire. So Roe v. Wade is the law of the land right now. That has been the law of the land for almost half a century, 49 years, right? So if you support this 49-year-old protection for Roe v. Wade and the rights that were provided in that holding, you will support 436. So again, I want to be very clear about the state of reproductive rights in the country and in New Hampshire. We are at a crisis moment, and as a woman, this is something that I think about daily, hourly, on the minute. I grew up after Roe, and I never, ever thought in my lifetime we would be in a situation where access to reproductive health would be at risk, but we are at that moment right now. We know that we are in a crisis, and Roe v. Wade is very likely going to be overturned in June. And we need these state-level protections so that abortion remains safe, legal, accessible, no matter what happens to Roe. And now is the time to do that for our New Hampshire women. So again, we are at a crisis point, and now is the time to do the right thing. We know that in May 2021, the Supreme Court announced that it would take up Dobbs v. Jackson Women's Health Organization. This is a case challenging Mississippi's 15-week abortion ban. And then we know in September 21, the New Hampshire Supreme Court allowed Texas law SB 8 to go into effect. So right now in Texas, abortion is banned effectively, right, after 6 weeks. And not only that, but in Texas, there's a private right of action. There's a bounty on anyone. Anyone can sue for a violation of this abortion ban. Both of these laws that are now in the Supreme Court directly contradict Roe v. Wade, directly contradict Planned Parenthood of Southeastern Pennsylvania v. Casey, which guarantee the right to abortion and prohibit states from barring it before the point of viability. The court cannot uphold Roe, uphold Casey, and also uphold Mississippi's abortion ban and Texas' abortion ban. We are at a crisis point. We have an obligation, if we support the right to access to abortion, to put New Hampshire level protections to protect New Hampshire women. Now, I want to point out that recent polling released last week showed broad support for abortion rights and broad support for the Supreme Court ruling in Roe v. Wade. And this polling is in line with historical trends. Multiple polls show, again, the overwhelming majority of women, of Americans, support the right to abortion access across the political spectrum, and that it is far from the divisive issue that is often represented in media or in state houses. We have a CNN poll, a Fox poll, a Washington Post poll, a Marquette poll, a Gallup poll. Overwhelming majority of Americans support Roe v. Wade. And here in our own state, there's New Hampshire support for Roe v. Wade. Our citizens' support for Roe v. Wade, so the access to abortion, is one of the highest in the country, okay? We shouldn't, if that's the case, we shouldn't be sending Granite Staters to another state to get the care they need when we are perfectly equipped to support patients by our incredible OBGYNs, right? We need to make sure that at any stage of pregnancy, we should not be forcing people out of state. And of course, we know any abortion restrictions disproportionately harm communities of color, people with low incomes, young people, people in rural areas, right? That puts abortion out of reach for people, right? I think that every Granite Stater should have access to the health care that they need, including abortion. Abortion is a safe healthcare procedure, and the government should not be saying what a woman can and cannot do with her body. Look, abortion is incredibly complex for the individuals involved. Everyone has a strong feeling about it. But even if we disagree, even if you would encourage your family member to get an abortion or not, it is not our place to make that decision for someone else. It's better left for the individual with her family and her provider to make that decision. So I am in strong support of this bill, and I hope people do the right thing, understanding the crisis where we are, understanding that 50 years of precedent might be going down and women will be losing access. I hope that we do the right thing and put state-level protections through this bill. Thank you.
Are there any further comments, any further questions?
Can I ask you a question, Senator Whitley?
Sure.
Okay, so if 399 passed, you do a great job on the floor. Then you pass 436, again doing a great job on the floor. Wouldn't abortion then be legal up to the date of birth, like a week before a fetus or a baby?
Senator, we are only talking about 436. This bill, as written, 436.
Thank you, Senator. I'm all set.
Okay. Are there any further comments, questions? Okay, we have a motion of ITL. Okay, is everyone ready to vote? Okay, all in favor of the ITL motion, say aye.
Aye.
Aye. Any opposed?
No.
No.
Okay, so it's 3-2. Who would like to take this out? Do you want to take it out,
Sure.
Senator Gannon? Okay,
Sure.
Senator Gannon. Okay. This is what I had down for today. The rest of the bills need some sort of work, either amendments, meetings with folks. So we are concluding our business for the day. Can I get a motion to come out of executive session?
So moved.
Moved by Senator French, seconded by Senator Gannon. All in favor say aye.
Aye.
Aye. Any opposed? Seeing none, thank you all very much. Okay. Pardon?
I know, right? Got myself on it.
Yeah, it's a whole different kind of paperclip session.
Yeah.
There should be like little.
Well, I think you were, and you'll do it again. I don't think we'll have any more chances.
So,
It's almost on the cusp of where everybody's released. It's like,
All right,
his native son is
let's head home.
in the middle.